This is the second part of a series of mini lectures on the topic environmental law and spatial planning. My name is Peter Young, I'm a part-time lecturer and I'm also working in the Ministry of Infrastructure and the Environment. With a lot of joy, I'm working in the learning environment of Delft University, and I'm combining 1 day of university with 4 days of practice. This second part deals with an introduction to environmental law. What is environmental law? Environmental law can shortly be described as the part of the law that deals with the protection of the human health. For instance, noise, air quality, soil pollution, and also the protection of the natural environment. For instance, nature reserve, wetlands. And also taking care of scarce items, for example, energy and clean water. Environmental law is important. It's important because there are also important aspects regarding urban development and spatial planning. Because people not only want buildings, but people need clean environment. People need clean air, clean soil, clean water. People also want to have a healthy living environment without noise nuisance, without air pollution, without safety risks. And people also want to live in a flood safe area, an area that is being protected against floodings. The question is, who looks after these interests? To give a short answer, it's not only the government that takes care of the environment. Because when we look at the Dutch Environmental Management Act, section 1.1a, every person shall treat the environment with due care. And this care can have two forms. In some situations, persons are obliged to refrain from acts to damage the environment, and in other situations, people are obliged to take every possible measure to protect the environment. Environmental legislation is quite broad, quite extensive. The environmental acts contain various quality standards and also procedures. And environment is quite broad, so it deals with air, water, soil, noise, nature, etc. And not only the protection of human beings, but also the protection of nature, animals, and flowers. So, environmental law is broad and extensive to protect water, air, nature, etc. In the first part of this series of mini lectures, we've talked about the environment on various scale levels, but also when we look at environmental law, we can distinguish various scale levels. So we have the European environmental law level, we have national environmental law. In the Netherlands we also have provinces. Provinces also make environmental law. We have municipal, local environmental law, and environmental law also has effect is important in relation to urban development and building construction. On the European level, we have a lot of European directives, for example, the Water Framework Directive. On the national level, we have the Dutch Environmental Management Act, that also contains rules regarding environmental impact assessment. On the provincial level, we have provincial ordinances that also aim to protect nature. And on the local level, we have environmental zoning in land use plans. European directives are very important. These contain standards, with the exception of noise and soil. On a European level, we don't have standards regarding noise and soil yet, but there are directives that regulate mapping and monitoring of noise, for example. And member states in Europe are obliged to implement European directives in national legislation. Because when these directives are not implemented in time or not sufficient, the European Commission can take actions and can also bring the member state to European Court, etc. European environmental law is also important because these rules aim at an equal level playing field. The same level of protection of environment and also the same market, fair competition. Environmental law has also impact on urban developments, and urban developments have to take the environment into account. And environmental problems have to be addressed early on in a construction or infrastructural project. And in practice, we see sometimes discussion about environmental and economic interests, but to say it very shortly, when project developers want to have a feasible project, they have to deal with the environmental facts on the ground. If the ground or the soil is polluted, you have to deal with the soil pollution because people don't want to live on a location where the soil is polluted. In the construction process, it's very important to deal with environmental aspects in various phases. In the initiatory phase, in the planning phase, and also in the realization phase. In the initiatory phase, all the possibilities have to be explored of the location. Possibilities of nature, wildlife, monuments, etc. In the planning phase, we need more information. And also research has to be conducted in the preparation of the land use plan. And an important research tool is called the environmental assessment. In the realization phase, you need permits and also dispensations. And also in this phase, sometimes further environmental research has to be conducted. For more information about environmental law in relation to spatial planning, I would advise to read this source, this book. I've written this book together with my colleague Fred Hopma. I've written chapter 7 about research obligations and environmental law aspects of spatial planning.